Ms. Grove and Mr. Horton, Mr. Del Bianco made reference to your testimony. Would either of you care to respond to what he suggested? Ms. Grove?
Yes, please. Thank you so much, Senator Cruz. You referred to our experience as a bad experience, and I understand how it could be chalked up to that, but I think it's a lot deeper than that. There was actually a statement in the applicant guidebook that prevented ICANN from being able to give our name to the other applicant because they had a number of uniform dispute resolution policy decisions against it already. That should have prevented it right there. But ICANN didn't follow its own applicant guidebook, and we were very shocked to find there was no one to hold them accountable to do that. The only group that could hold them accountable was the NTIA, and they had decided to take a hands-off approach to it. So even though it is complicated, and even though people have spent a lot of time working on it, and we do have a person that's involved in the multi-stakeholder group on our behalf, you don't have to spend thousands of hours doing that or be a $800 an hour ICANN attorney or a computer guru to see that if you have to bring the whole world of multi-stakeholders together to hold ICANN to follow its own rules, it's going to be very challenging to hold them accountable at all.
Thank you, Mr. Chairman, for the opportunity to respond to that. As to the suggestion that I spend time getting involved in the ICANN process, I've already lost countless hours of my life doing that, talking about compliance and other issues. The problem is that ICANN does not follow what is already written and has already been developed by the multi-stakeholder community in the Registrar Accreditation Agreement. And as to why that happens, the problem is a fundamental one of transparency. When you try to get to the core of the problem, it's like a secret court. Now, part of the problem here is that the multi-stakeholder community is, the fact that it's open is a good thing, but anybody can be involved in what is a very complicated process, and it's hard for a lot of entities that have a stake in the future of the internet to be involved in these complicated and very bureaucratic groups without dedicating a full-time employee or employees to these processes. Some of the most motivated sectors are the registrar and the registry sectors, which have a lot of power in the multi-stakeholder community and do not want compliance to exercise the functions that are clearly written in the Registrar Accreditation Agreement. So that's part of the problem.
Thank you, Mr. Horton, and I want to thank each of the witnesses on the panel. I will say we heard a lot of interesting expert testimony. I thank you for the time you put into writing your testimony, to coming here and answering these questions. In my judgment, the most powerful and most troubling testimony we heard today was that it was indisputable that this administration's transition, if it went forward, would increase the power of federal governments, of foreign governments, including Russia and China and Iran, and decrease the power of the United States of America, which is the only entity bound by and able to fight to vindicate the First Amendment. I'm reminded in the 1970s when President Jimmy Carter chose to give away the Panama Canal, which America had built, and I believe that undermined U.S. interest and U.S. sovereignty. And likewise today, the internet is working, and this is a solution in search of a problem that poses real risks to the liberties of Americans. And so it is my hope that Congress continues to exercise its Article I authority to protect free speech on the internet, to keep the internet free of the coercive authority of foreign governments that would love nothing more than to silence and censor free speech.